Hi, everyone. Thank you for joining episode 160 of the Immigration Lawyers Podcast. Today, we have a great interview and recap of federal legal decisions that have happened in the circuit courts with Kevin Gregg. Kevin Gregg, a fellow podcaster whose podcast is Immigration Review. I'd strongly recommend following that as well for updates on immigration law. He goes over some big cases, and we discuss the political and legal consequences of these decisions and go into a little analysis of it. We do this every month, and I really enjoy doing these. So I hope you have a good time on this one. If you're listening to this on anywhere on YouTube or on podcast, please like, subscribe, and leave a 5-star review and a nice comment. It helps other people learn more about the program. So that's really helpful if you do that. Also, the Immigration Lawyers Toolbox, the parent company of all this stuff that I run, has monthly membership for a lot of great information and CLE type info and training and education. So email me at info@immigrationlawyerstoolbox.com for information about that. I think you'll find it really helpful and really help you expand your firm, both on the knowledge of immigration and practice area side and on the marketing side as well. I also want to thank our sponsor, DocketWise. DocketWise is a great form, software, case management software, a lot more. They just added French and Portuguese language, their questionnaires, in addition to the English and Spanish language questionnaire that they have. So it really helps you connect with your clients. Some of them who are not tech savvy could answer stuff with text messages even. It's a wonderful program. They're sponsored the website. If you go to their website, if you go to www.docketvise.com/immigration-lawyers-podcast, and we use the code Immigration Lawyers Podcast, you'll get an additional 10% off the annual fee. So if you sign up for a year, even if you have a month-to-month right now, add that annual program. They already have a price cut for buying 12 months worth. You'll get additional 10% off that. So I strongly recommend doing that and supporting them and supporting the podcast as well. So we keep this kind of information and just have more and more episodes and information, and to promote the immigration practice and the immigration bar, because I really like to highlight fellow colleagues that are doing great work and to help you adjust to the legal changes and practice changes that are affecting our practice area, which is crazy right now. The election's pending. They just happened. We don't know what's going to happen tomorrow with it. Hopefully things won't get harder and more difficult with our practice area. but that said, the toolbox is a tool there to help you overcome that. And let's just get the program started with that.
Welcome to the Immigration Lawyers Podcast, a part of the Immigration Lawyers Toolbox, an education and marketing publication for the immigration law community that includes legal updates, interviews, discussions, education and CLE material, and more. Note that the information here is for general education only and not intended as individual legal advice. The laws change frequently, so you should consult with an attorney about your specific case. For more information, please visit immigrationlawyerstoolbox.com.
Hi, everyone. Thank you for joining us for a wonderful episode. We're going to have our regular guest every month, Kevin Gregg. Kevin is a partner. And I should memorize their entire firm name, but you have Kurzban in this, so it just kind of much absorbs it all. And he's got his great Kurzban book. The new version came out this month or last month, so I know those are selling like hotcakes for sure. Thank you, Kevin, for coming on to talk about some cool federal cases, cool or uncool federal decisions that have popped up in the last month.
Yeah, thanks again for having me, John. I really look forward to this. I can't believe it's been a whole nother month. I'll tell you, I was out in San Diego for many years before, but then I'm from Florida. I was in Florida. I am freezing in San Diego. It is cold. I'm like in sweats all day.
Yeah, it's a beach town, but it's really cold. It's not fully a beach town. That's the summer, yeah.
It's freezing. Sitting here reading decisions. Kurzban, Tetzelli, and Pratt. I think people get tripped up on the Tetzelli.
That does it. But I'm going to make a note. I got to show respect to the whole firm and definitely say the whole name from now on. So let's jump into it. What's the first case we're going to talk about today?
Well, I thought that maybe we'd talk about two cases that I'm going to actually discuss on the podcast coming up on November 2nd because they're fresh in my mind and they're interesting. The TPS case out of the 8th Circuit and the detention case out of the 2nd Circuit. And then maybe if we have time, we'll talk a bit about the terrorism case out of the 11th Circuit 2 weeks ago.
Okay.
So I guess, it's a sneak peek to the Immigration Review podcast coming up in 2 days. I don't know how long it takes for you to get these out, so maybe they'll come out at the same time.
Beat you to it or not? Yeah.
But yeah, look, the Eighth Circuit one, it's real. I find it really interesting. It's about TPS. It's Velasquez v. Barr et al. Number 19-1148. It was published on October 27th. And in a nutshell, it says that individuals who obtain temporary protected status have been inspected and admitted within the meaning of INA Section 245A, which is the prerequisite to adjusting to lawful permanent resident status if you have a qualifying relative or if you have an employer who can sponsor you. So it's a big decision, at least out of the Eighth Circuit. And in that sense, it aligns with cases out of the Sixth Circuit and the Ninth Circuit. And it is flat up against cases out of the Third, Fifth, and 11th Circuit. So pretty big circuit split on whether or not these individuals, of which there are about 400,000 in the United States, can eventually adjust to lawful permanent resident status through their U.S. citizen children or spouses.
Now, I've always been confused on how an issue like this could be such a toss-up between the circuits. I mean, do they make any reasonable arguments as to what the differences are, do you think? Because there's another decision by the Fifth in Velasco v. Crockett, which recertified their decision in the Fifth Circuit that TPS is not admission and you can't use it to adjust status. But to me, it was pretty straightforward. The TPS is status, and you got status, you got status. But what kind of stuff's going on that makes these differences?
Yeah, look, I mean, and maybe it's my former government experience talking, because actually, I think that it is actually a pretty tricky issue, that it's not so black and white. And I, quite frankly, I'm no appellate judge, nor have I thought about it so hard. I'm not sure where I'd come out on it. I mean, TPS is definitely a status. Everybody agrees with that. The TPS is a temporary protected status. But whether or not that then constitutes inspection and admission is really what's at issue. Now, admission used to have one term, but then the BIA has been expanding what an admission is. There used to be admission is just at the border. It's only when you get to the border. But the circuits plus the BIA have, over time held that, for example, adjusting status in the United States counts as an admission. So the term admission has been expanding, plus it's kind of ambiguous under the INA. Inspection, too, I mean, seems pretty clear what that is. But, I guess there's policy arguments against it, and then the statutory arguments get really complicated. But the policy argument, right, is, right, Congress created temporary protected status in like 91, 92. If they had intended that to then be a path to permanent status in the U.S., maybe they would have said it. Maybe they would have created some provision in there. I think the argument is this is kind of using a legal loophole to get people who are supposed to only have temporary status, permanent status. I think that's the policy argument from the other side. And then there's a bunch of textual arguments as well. And I'm not going to go through all the government's one, but the Eighth Circuit, really agreed with the Ninth Circuit and the Sixth Circuit, putting a lot of its authority on the text. And that is under the statute, quote, the admission to the United States of any non-citizen as a non-immigrant shall be for such time. Well, hold up. I apologize. Let me make sure I read the correct portion of this, okay? Because it gets complicated.
For sure. There was another case, just quickly, out in Northwest, I think, where they said like delivery of the drug isn't necessarily something. Did you see that one?
Yeah, I did. That was an interesting one too. And so I guess back to the TPS one. So the TPS statute says, I quote, they may temporary protected status beneficiaries may, quote, remain in the United States, quote, temporarily and work in the United States, and, quote, for purposes of adjustment of status under Section 1255, a TPS beneficiary, quote, shall be considered in being and maintaining lawful status as a non-immigrant, end quote. And so the government wants to read that as saying, okay, that just means that they're not accruing unlawful presence, that the statute says that these people can be thought of as if they're non-immigrants, that they're not accruing unlawful presence, and they have all these other benefits. But the Eighth Circuit agreed with the Sixth and the Ninth Circuit and said, no, they're using the term non-immigrant. And a non-immigrant has necessarily been inspected and admitted. And that's really the end of the story. The statute calls him a non-immigrant, so we're going to treat him as a non-immigrant. And we're going to treat him as a non-immigrant for adjustment of status purposes, so they can adjust status if they have a qualifying relative.
Another thing about that language is that, to me, that means if you have TPS, you could change status too. But that's, they don't accept that. But if it's a non-immigrant status and you don't do anything to violate that status, you should be able to do I-539 and I-129 and not have to do consular processing for it. But that doesn't fly either. So that's why I always say, to me, it's open and shut, because if you're non-immigrant, you get the powers of a non-immigrant. And as long as you abide by those, then essentially it's an NIV category, even though it's temporary. Yeah, NIVs are temporary as well. But, a split that this deep seems like it's going to go to the Supreme Court. And we were talking about earlier, I don't think that it's that controversial where the court wouldn't take it. They're like, yeah, whatever, it's TPS, the mainstream media is going to brush over this. It's too complicated or too in the deep annals of immigration law for them to even care. And this could go either way, especially with the shift right now that's happening in the court. I can see this going either way.
Yeah, but a lot of the justices that we would call conservative, they really do like the statutory interpretation. I mean, the notice to appear cancellation of removal case, of course, the Ferreira v. Sessions case, that was 8-1. So, when it really comes to the statute, you never know who's going to do what. And the statutory text in the TPS statute for this issue seems pretty favorable. Mm-hmm. The Eighth Circuit rejects the Fifth and the Third Circuit's analysis, the 11th and the Third Circuit's analysis, primarily because they completely just brushed aside the whole idea about the non-immigrant. They didn't even analyze that under the statute. So it seems that maybe the Eighth Circuit has the better statutory argument.
It's kind of one of those things, do we want it to go to Supreme Court just to make a final decision to help the TPS people in those jurisdictions? Well, I would imagine most TPS people are in jurisdictions that are accepting of it. California, I don't think New York, which jurisdiction? Because I know Ninth, was it Fifth or something, Eighth? So it's like
the Sixth, the Ninth, and the Eighth have now held that it's inspected and admitted. So that's some Midwest states, and then all the major states in the Ninth, and then some central Northwest states is the Eighth Circuit. So I don't think the Second Circuit has spoken yet. I could be wrong, but certainly not in a published decision. And I don't know. I mean, I hope that Congress does something for all the TPS holders, regardless of whether or not they have a U.S. citizen spouse, and the DACA individuals and all of them. I think that it should be done by Congress, but all of these things become necessary when Congress doesn't act.
No, I was about to say, I wonder what field offices that aren't part of these jurisdictions, these appeal court jurisdictions do. But as I recall, either the BIA or an AAO decision was recognized as a precedence where they said that except for Ninth, and I guess now the Eighth got added in the other circuit, TPS is not admission. So they told USCIS field offices that they can't accept it unless, that circuit says that. So we'll see what happens with all of that.
So this is against two BIA decisions, really. I mean, there's the BIA decision that is directly against this, that says it's not inspected and admitted. And then there's the AAO decision, I apologize. And then there's the memorandum and the AAO decision just a couple months ago talking about a similar parole issue for the TPS individuals who leave the United States on advanced parole and then come back in, and USCIS saying that's not a parole, because in order to adjust status, you have to be inspected and admitted or paroled. So in the 6th, 9th, and 8th Circuit, that's not even an issue because it's already an inspection and an admission, right? But in the other circuits, there was still an open issue, except in the 11th Circuit, really. No, not even the 11th Circuit. In all the other circuits, there was an open issue of whether or not, okay, if you leave on advanced parole, come back in, you've been inspected and paroled. It doesn't matter that it's advanced parole.
Yeah.
So you can adjust status to a qualifying relative, and the USCIS took that away last month, although that's subject to at least one injunction as we speak.
Yeah, it's just mind-blowing, these kind of decisions, like what's going on. So I can't believe it. And it just shows like immigration law is such a mess to be this split. And are these kind of issues? These are like, it's just so weird. It's kind of very frustrating. I'm in the Ninth Circuit, so I'm lucky. Most of my clients, when I deal with this stuff, I don't have these kind of problems. But if you're practicing in some of these states, I mean, it's a battle every day going to work.
It's
If
a ba-
you're, yeah.
it's a battle, and I don't know. There's the argument that the INA was poorly written, or there's the argument that immigration attorneys are just too clever. I like that latter one. That makes me feel it's probably that it's a poorly written statute, but I like the idea that it's because we're clever.
I mean, it's a little bit of both. Immigration's so complicated. It's going to be impossible to write any statute that's not going to have a million holes in it, or like just circumstances change. And then, it's our job to really pick at this stuff and make it work. But that's going to be lingering for probably another year. But I bet on it that we're going to get a decision on that, or at least certiorari grant on that one.
Yeah.
But who knows? So the next case was a detention case. I think you mentioned. What was that about?
Yeah, Velasco, Lopez v. Decker out of the Second Circuit on October 27th. Detention cases, they get me animated. I try not to let emotion get involved, but I don't know, something about taking away someone's freedom. Like, it seems like it should be a really serious thing, and we seem to do it pretty willy-nilly when it comes to immigrants in the United States. And so, this is another issue that's going to make its way up to the Supreme Court eventually. In this case, it arises out of district court. It's a habeas case. And Mr. Velasco Lopez, he was detained for 15 months. He had DACA. He lost it because of a DUI. And then he got like another DUI arrest, but that didn't end up getting convicted. But while his removal proceedings were going forward, he was detained for 15 months. He was denied bond twice, with one DUI conviction and then a DUI charge. And the immigration judge said that he couldn't meet his burden because even though it was just a charge, he couldn't produce sufficient evidence to show that he wasn't dangerous, even though he wasn't convicted for it. And it's all about burdens. And so, having lost twice before the IJ and gone up to the BIA, he filed a habeas action, which is a difficult thing to do because the INA really takes away the ability for non-citizens to challenge detention decisions in federal district court. But they got around it. It was a lot easier before the Supreme Court's decision in Rodriguez v. Jennings 2 years ago, which overturned the whole batch of Ninth Circuit cases about how this whole procedure should work. But it's the Jennings v. Rodriguez v. Jennings v. Rodriguez, however you want to call it, left open the possibility that district courts had the authority to grant habeas relief where there's been a constitutional violation or a violation of law. That's what is going to go to the Supreme Court probably eventually to say they said that was not before them, so they didn't do anything about it in Jennings v. Rodriguez. And here, the district court and the Second Circuit found that there was a due process constitutional violation when a guy has been detained for 15 months based on a DUI, really based on anything, without having a hearing in which the government bears the burden by clear and convincing evidence to show that continued detention is warranted. So this guy was detained under INA Section 236A, not mandatory detention under 236C, but regular detention under 236A, and he couldn't meet his burden twice. After 15 months, the Second Circuit is saying, I'd say pretty much with all non-citizens who aren't mandatory detention, that you have the right to a bond hearing where the government bears the burden to show that your detention is warranted. Now, they were very clear to say this isn't a hard and fast 15-month rule, but I don't know why this would be distinguishable from another 15-month rule. Also, there's no reason that this decision couldn't be written for 10 months of detention or 8 months of detention. It's just all about when you bring your habeas case. And they do say it's under the Matthews test, the Supreme Court due process, 1976 Matthews, the Eldridge test. And the Second Circuit did say that as you're detained longer, the interest in detaining you decreases. So more time does help your habeas case. But, if the client is willing to fight it out, I'd file these. You can file these at any time and after 6 months for sure.
This issue of being detained, I think it's at the core of our republic. And whoever's going to consider themselves a patriot always has to consider whatever the situation is, whatever the charge is, being detained without right to review in open court is one of the most dangerous things that exist for our health of our country in any format. Something that should be talked about like every day on all the shows.
Yeah,
Like the most important thing we talk about more than anything, really.
it is. It is. If we're going to use detention as a deterrent in place of sound immigration policy, which we're clearly doing, that's something that we really should debate. I mean, I guess they did it in '96 with Ira. I don't know. I was young, but it seems like a big deal to say we're going to put non-violent individuals, non-dangerous individuals in prison, and with arriving aliens, asylum seekers, they're not even eligible for a bond hearing, even if they pass a credible fear test after Attorney General Barr's decision last year.
Yeah.
We're going to detain them forever, and they have to put a case together without an attorney. I mean, if this is what we're going to do and really take away these freedoms for these people, I don't know. I just feel like a lot of Americans would not agree with such a policy if they really thought about it.
Mm-hmm.
Yeah. Yeah. The detention gets me riled up.
Yeah, I mean, is really disgusting, but I think, I can't remember the details of it, but there was one guy they tried to get for terrorism. They couldn't get him, but he was deportable. So they just detained him under like some statute indefinitely. So it was like an immigration loophole that came into national security that they used. And I think got out. Do you remember the case I'm talking about? What I'm talking about at all?
No, I don't remember it. No.
Just so this guy, they couldn't hold on to him for national security reasons because they saw they have no evidence. So they put him, he was in deportation. So they put him in detain him and indefinitely. It was going to be indefinite detainment forever. And they're like, this is BS. We can't do this. And I think a judge said to get out of here with this kind of stuff.
I mean, like, don't get me wrong. Maybe I'm naive. I mean, I have faith in the FBI to an extent. I mean, if the FBI isn't going to bring criminal charges against somebody, and the FBI isn't going to do whatever they've got to do to keep that guy in detention, and they're okay with letting ICE just be the ones in charge, it seems to me that person's probably not so dangerous. Maybe I'm naive. And, when it comes to the individuals who have been convicted of crimes, and this idea that Donald Trump is always talking about with criminal aliens and letting them out on your street, it's only with immigrants that we have this idea that they're dangerous after they've completed their criminal sentence. Never is this discussed. A regular American does his sentence for a horrible crime, and he gets released because he has paid his debt to society, or she has paid her debt to society. And no one talks about this being a really dangerous person still, except maybe with sex offenders, and so we make them register. But this idea that because you're an immigrant, even if you've completed your crime, you are still dangerous, to me, just quite frankly smacks of racism. I mean, there's no difference between someone who completed their criminal sentence as an immigrant and who's done it as a U.S. citizen as to dangerousness.
Yeah, it's ridiculous. I said the FBI at this point has tools to snoop on everything and track everything and see everything like up. I was going to say some gross kind of stuff. They look up anything they want. So if they can't pull to get up evidence in the kangaroo courts that are like these hidden courts that we have for terrorism, then I mean, come on, like you got nothing. But we'll see. But it's a depressing thing to talk about. But I think it's so vital that we do talk about it, because it's not heard about the idea of detention and how disgusting it is to cage other people. I mean, we have the biggest cage population there is in the world, and after China, they say. And China has internment camps. It's like, what? Right. So what's going on? I mean, probably their numbers are more hidden than ours. But when you think about that idea, it's just ridiculous. And it's something that we really have to change. And, elections are happening to go on the partial political side. Obviously, most of the crew listening to this podcast is voting one way. But from what I hear, and I don't know the stats exactly, but the crime bill in 95 that, Vice President Biden helped pass was a big reason we start caging people en masse. So, and Ira at the same time, I'm not sure which way he voted on that. But it's bipartisan. I think it's bipartisan, this taste for immigrants that goes both ways, because we've had, 8 years Obama and all we got was DACA. And it's like, what? That's it? So we really have to push that changes happen and not just pay, just vote some just to do it because we don't like the other guy necessarily.
I feel compelled to say 3 things based on all the things you just said.
Let's do it.
And one, I think Joe Biden's probably come around, and I think he's publicly said he erred with those crime bills, but it doesn't absolve what he did. But I can guarantee you that if Donald Trump had been a senator in 1995, he would have been all for those crime bills. So I don't like staining Joe Biden based on that. He did do it. I like to think he's come around, and I guess we were a different time because the Democrat signed IRA in, but as to DACA and Obama, I wasn't as politically conscious at the time, but I do know people who were part of comprehensive immigration reform, and it's not just, Marco Rubio, whatever the gang of eight, whoever the 4 Republicans, Dick Durbin on the Democrat side in the Senate, they were an inch away from comprehensive immigration reform, and then the Republicans took the House. And a minority of the minority party, the minority of the majority party, the Freedom Caucus in the House, about 40 individuals said, no, we're not doing this. Even though the majority of Republicans in the House were on board for comprehensive immigration reform, Boehner couldn't get the votes. The whole thing died. It shot Marco Rubio's presidential aspirations to shit. And Obama was left with no immigration reform. So I don't know. Obama has blame. They were not perfect on immigration, but man, he had the freedom. They were an inch away, and I blame it much more on the extremists in the Republican Party than I do on Barack Obama and Joe Biden.
I hear. I have to look into that to see what exactly happened, but I hear you. But not to be an apologist for Trump, because I definitely don't want to apologize to that guy. But he is passing these reforms on criminal justice reform. We saw Kim Kardashian and them going, and so. But maybe in '95, because when that thing happened in New York where those poor kids got busted for, he was like all on board on like executing them or something like that. It was unjustified. So yeah, for sure, I would imagine he would have done that and worse at the time, 1995 especially. Things have changed a lot. I mean, in our lifetime, things have changed a lot culturally. It used to take like 1,000 years for these kind of cultural changes to happen. But within our lifespan, all the LGBT stuff, wow, we live in a rapidly changing period of time. It's pretty chaotic even. A lot of it to the good, but it's unbelievable how fast things are changing.
It is. When I get down about the current state of affairs, I think my parents were protesting against, Black people being separate but equal. I mean, it's, even though Trump is kind of like a mini George Wallace, it is impossible to have a George Wallace as president today. And that guy ran 3 times and got double-digit votes in the 60s and 70s. And Jimmy Carter had to say, I'm not taking your votes, George Wallace, and the Democratic Party doesn't want anything to do with you. But that was only 40 years ago, where you could legitimately go out and say Black people are less than and they need to be separate from us. So I guess, and we're not at war in Vietnam, right? So, with the big picture, it gives me hope because we are so much farther than we used to be.
There has been rapid change. Whenever you have changed really fast, just the nature of anything is there's going to be pushback against it. So it's expected that even people who will come around will at first just be shocked by the rapidness of the changes until it becomes more accustomed. So yeah, on an optimistic note, whatever the situation we see in the news and the brutality that's happening, it's still minuscule really to 50 years ago they were doing. It was drastic. Now it's changed. It's more hidden, and then the racism and all that kind of stuff. But internet, I think, is a big part of this. It gives an opportunity for people to grow. And just for me, immigrant child a child of immigrants coming in first generation to have a platform like this, the communication allows a lot greater power and scope and understanding between people. So I'm totally, again, general, whichever way. The only thing I'm not optimistic is for immigration law, but the rest of the way I think the American people will overcome it. The immigration part is just the executive has so much power over it that it's such a catastrophe. I never would imagine the executive orders would be so rampant. The BIA would be doing this kind of stuff left and right, and Stephen Miller would be this successful. you gotta give this guy. He's got some immigration lawyers apparently on his side that know exactly how the nuance of this stuff work, and some of it just he's shoving it through, even though it's ridiculous. It's you on that end, politics outside of all this.
I like to think the wheels of progress, they keep progressing, even if there are setbacks. I hope that is the case. I guess, before we conclude, to go back to the immigration real quick, we got a little time for a terrorism case, the Hincapi Zapata v. U.S. Attorney General case out of the 11th on October 13th. I think it's a material support of terrorism case, and the case that they always are really interesting to me because this provision of the INA, it is so expansive, and it seems that DHS is really waking up to it over the last couple of years of just how expansive it is. And with the two board decisions, one that said there is no de minimis exception, and the other saying there is no duress exception to the material support of terrorism.
For those who aren't familiar, how expansive this idea of support is. Could you explain more what it means?
Absolutely. I mean, the material support of terrorism bar, it's under 212A3BI, whatever, a bunch of stuff under 212. You look at the act. But if you have materially supported, and there's three tiers. There's tier 1, tier 2, and tier 3. Now, I can't remember what tier 2 is, but tier 1 is a designated terrorist group by the Department of State. Tier 3, as I recall, are just entities that are found to have committed acts of terror, even though they're not officially designated as terrorist organizations. And if you have materially supported those entities, you are barred from all immigration benefits. And this is, everything. It's do not pass go, do not collect $200. There is no exception written into the statute except at DHS's sole discretion may it waive this inadmissibility provision. And most of the circuit courts now and the BIA are interpreting that to mean because DHS has this discretion to waive it, that must mean that immigration judges have none, that there are no exceptions. And all you can do is go to DHS. But as this 11th Circuit case makes clear, you can't even go to DHS until the BIA has ruled. So you have to have a final order of removal before you can go to DHS to ask them to waive the ground.
Wow.
And I've never heard of anyone succeeding in it. I don't even know what the process is.
Yeah.
I don't know if anyone knows what the process is to get them to do that. And what incentive does USCIS, DHS have to waive material support of terrorism? And terrorism's bad. I certainly don't condone it. But you look at the facts of something like Hincapi Zapata and what it means. I mean, many years ago, the U.S. government designated the FARC in Colombia as a tier 1 terrorist organization. All right, fine. I mean, I'm certainly not a supporter of the FARC, but also I don't think that the FARC is the same as Al-Qaeda.
Yeah.
And when you think terrorism, I'm not sure you're thinking FARC right then and there. Maybe we're getting a bit overbroad. The Trump administration just labeled an arm of Iran's armed services as a terrorist organization. Again, not sure that's what we were thinking about when we're talking to. They might be bad. I don't know about that's what terrorism is supposed to be. But because the Board of Immigration Appeals, because of that carve out with DHS, the board has held that there is no duress exception. And in that case, it's a matter of ACM. And in matter of ACM, I believe Miss ACM was forced to watch her husband be murdered by guerrillas in El Salvador. And then he dug his own grave, and then they shot him in the grave. And these guerrillas were in her house, and she cooked him breakfast the next day because they forced themselves in. They said, cook us breakfast. Yeah. And so she supported them under clear duress, but because the board said there is no exception. So Miss ACM, who is a legitimate asylum seeker, is barred under the material support of terrorism bar. To me, that's an absurd result. And it's kind of similar with the Hincapi Zapata case. This guy was extorted by the FARC in Colombia, and he paid them $100 at threat of death. And when they said that's not, and then when they kept extorting him, he fled. And I don't think he applied for asylum, but he could have, right?
Yeah.
Based on extortion demands. And because he was extorted out of $100 of the FARC, and that means he did the material support of terrorism that barred him, in this case, from adjusting status. To me, that can't be what Congress meant with the material support of terrorism bar. And it's because these circuits and the board are finding there is no duress exception, there is no de minimis exception, that just cooking breakfast is so minuscule that it's not really a support. None of the exceptions.
How does federal judges say this is crazy? I mean, I don't know what kind of standing or power they have or that, but that doesn't make any sense. When that case came with that woman just cooking breakfast for them, and they said tough luck, I'm like, what? Like, what American would agree with that? Like, I don't know.
That was the board, but I mean, look, it comes back to statutory interpretation that you and I were both cheering when we were talking about the TPS case, and now we're saying it's terrible. But to me, it comes back to Congress. Write a better statute. Somebody's got to be in that room and say, "Hey, guys, like this might do the matter of the Miss ACMs of the world." Maybe they did think about that, and maybe it was some sort of deal made in Congress. I hope not.
When we think about comprehensive reform, there's things like this that got to change. There's TPS that got to change. There's L1 situations that I want change. It's just so many that eventually when what is that saying, the camel trading or something like that, when you're trading whatever this and that, so many of these are going to get lost, and we're still going to have problems with this. So even comprehensive reform is difficult. I mean, this one on its own should just, there should be some sort of congressperson pushing it, but there's no money in it. There's no political clout to try to argue this.
It's kind of political suicide to be the guy who's fighting for terrorists. But I would just one more nerdy thing that I did say on the podcast when I reviewed it 2 weeks ago. There is the shining light in it. The material support of terrorism bar, it specifies like 10 things, including funds. So the $100 are funds. So that cuts it.
Mm-hmm.
And those funds don't have a de minimis exception because they're articulated in the statute. But as I read this 11th Circuit case, if it's not specifically articulated in the statute, such as what Miss ACM did with just cooking breakfast, then there has to be a de minimis exception for various statutory analysis words. So the 11th Circuit might not have meant to do it, but with this case, they might have partially overturned, or not overturned, but not followed matter of ACM as to acts that are not specifically listed in the statute. So, I mean, a small victory out of a pretty rough case, but, I think it's something worth noting.
Definitely. So, I mean, there's a lot more interesting cases that are popping up, but we could keep talking about this forever. Do you have any? Well, your firm, by the way, got a great win on a positive note for an EB-5 case about loans based on for the investment coming from a loan, which is excellent.
Cash is cash.
Yeah,
that's the case is. Cash is cash.
So I bet you guys must have been really happy about that win, and it helps out a lot of people because the loan system is needed for the EB-5 program. It just makes sense to have something like that.
No, we're very happy, and got to give a big shout out to Ira Kurzban, John Pratt, Helena Tetzeli, and Eddie Ramos for that big win. It's a huge case, and it's great to see that happening.
Wonderful. So as a reminder, everybody, the podcast is Immigration Review. You can find it wherever podcasts are. Probably a lot of people are listening on iTunes. But you do a great job breaking down this stuff. And a lot of my listeners told me they listen to your show as well. And so they really enjoy it. They also tell me they like having you on here talking about it. We need to so come back more often. We'll be back in next month. And, there's more decisions. We might make this a bi-monthly kind of thing. Is bi-monthly twice a month, or is that every 2 months? But
I'm not sure. But I got my podcast commitments, I got to cut it somewhere. But,
yeah.
Well,
Well, I enjoy talking with you and inserting my own political biases in here, or just political opinion. While you're just saying the facts, I'm jumping in there with my little thing there. I enjoy it.
It's a lot of fun. I enjoy it too. And look, we're going to be talking in a much different world in a month. Let's see.
Either way, it's going to be wow. The wild area of law that we're in, probably the most exciting area of law. And I would say, the positive of it is I'm nonstop I stopped teaching at law schools, but my classes were getting bigger and bigger. And I have more and more students saying, this is what I want to do. So as burned out as we're getting, we have a fresh batch of people coming in, much larger than it's existing. And that's why, that's why these podcasts are so popular, because more and more people are trying to hear about this stuff that are coming in our field. So it's a good fight. I mean, our army's growing, and that's always a positive thing, especially if they're smart lawyers and stuff, not just regular kind of people. So it's a very powerful situation we're coming into.
Yeah, I hope so. I have faith. I think we've got a bright future.
Awesome. All right, Kevin, thanks so much for coming on. Catch up with you next month.
Bye, John. Thank you. It's a pleasure.
Thank you for listening to the Immigration Lawyers Podcast. The Immigration Lawyers Podcast is a part of the Immigration Lawyers Toolbox, a training and marketing program for immigration lawyers. For more information about that, please email us at info@immigrationlawyerstoolbox.com. Also, you can find more information and updates on the LinkedIn page for the Immigration Lawyers Toolbox, as well as a private Facebook group for practicing immigration lawyers. You can email me for information about that as well. And also the Twitter page is a great place for updates. Until next one, have a good one.